Alright, 6820061, actions against license and penalty. Denial with any provision for license, annual license meaning for the accreditation agency's license, agent's license, approval of the use of the terms of college, university, approval of the modification, approval of the occasional elective, the clinical clerkship, the other authorization under the claimation of the jurisdiction shall be defined under the determination of the Commission for application does not meet with the requirements of Chapter 1005 of the Florida State Statute for the applicable standards of Chapter Rule 6E1 and 6E2 Florida Administration Code, the specific grounds of state with the sections 1532.7 and 1534.3, 1538, and Florida State Statute 2, probation, provisional license for the annual license being accreditation agent license, and other authorization under the Commission jurisdiction shall be placed on probation if the Commission finds the infraction of any of the grounds for the enumerated with the subsection 4 with the rule with which the Commission judgment threatens efficient operation of the institution of the quality of the educational program, surface or authors damage for the reputation of another institution to deceive the public. B. The Commission shall impose the conditions designed to correct the infraction and identify to overcome the effect of such infraction shall require the submission periodic with the progress report for the step be taken to comply with the conditions to correct the situation on announced staff. The visits shall be made with the institution necessary to do a manner of the activities. Institutions of the agency placed on the probation shall provide with the satisfactory documentation Commission remedial action has been taken or corrected the situation activities leading to probation. When it is documented with the Commission situation activities have been corrected, policies have been adopted, the institution preventing the reoccurrence of the infraction, the Commission shall have removed the probation competency of the evidence for not represented, showing the situation activities leading to the probation having to be corrected for the period of time specified in the commission by the Commission, and similar infractions occur, the procedure shall be initiated with revocation of license or other authorization. See if the conditions set by the Commission in conjunction with the probation and require oversight with the monitoring of the Commission with the staff of the Commission shall impose the administrative fine with the amount of the reflective administrative time required for the specific case up to $5,000 is provided in Section 1538.1. 3. Revocation. Any provisional license, annual license being for the accreditation agent's license or other authorization Commission jurisdiction shall be revoked for the Commission finds an infraction any grounds enumerated with subsection 4 with the rule of this Commission judgment is so with the serious threatened condition, operation, institution of the health and safety welfare of the student, staff of the general public, the institution agent, and then continue with the agency engaged in activities within compliance with applicable laws and are after directed with the Commission to cease and desist. C. The institution or agent has failed to correct with the allotted period in situation activities with the probation has been imposed. If the license revoked for the college agent with effect for the CLCs for the operation in Florida, any new application for the licensure shall follow the procedure requirement for the applicable statute and regulation rules. For the grounds for imposing disciplinary actions, obtaining of the Commission with the fraudulent misrepresentation, bribery throughout an error over the Commission, action against the license operation imposed used under the authority to another state and territory country. Delegating professional responsibility or who is not qualified in training experiences with a license to perform the responsibility, false, deceptive, misleading advertising. Conspiring to coerce and intimidate to preclude any other license with lawful advising, advertising his or her services, failure to maintain license standards as set forth in Section 1531, 1532 for the applicable rules, failure to comply with the fair consumer practices set forth in Section 1504, 1534 applicable rules, previously operating with the institution in a manner contrary to the health, education, and welfare of the public as described Section 1538.4 of the statute, failure to license comply with any of the conditions and limitations placed on the Commission under upon its licensure and operation. J. Failure to notify the Commission of the change of address, repeatedly violating any provision in Chapter 1005 Florida State Statute Human Rule adopted pursuant thereto. When operating revoked and suspended with an inactive license, M. Violating a law for the Commission were previously entered with the disciplinary hearing of the filing to comply with the lawfully imposed issued subpoena. N. The failure of license to notify the Commission of the closing institution of the campus. 5. Based on consideration aggregating the mitigation factors present in the individual case where the Commission may deviate from the recommended penalty, the Commission shall consider aggravating the mitigating factors of the following. 1. The danger to the public. B. The length of the time since the violation. C. The number of times the license have been previously disciplined by the Commission. And D. The length of the time the institution has been licensed as a school. E. Actual damage, monetary, otherwise caused by the violations. E. F. The deterring effect of the penalty imposed. G. The effect of the penalty upon the institution's ability to stay open. H. An effort of rehabilitation of the institution. I. The actual knowledge of the license pertaining to the violation. J. The attempt for the institution to correct stop violation, refusal, institution for the correct stop violation. K. Related violation against licensing in other state, including the fines for the guilty and innocence penalties imposed for the penalties served. L. The actual negligence in license pertaining to any of the violation. M. The penalties imposed for the related offenses. N. The peculiar pecuniary gain to the institution. The number of the complaints filed against the institution. Any other relevant mitigation aggregation factors under the circumstances. Investigation behalf of the commission shall be carried out and provided in section 1538 Florida State Statutes. Probable cause. Determination of probable cause shall be made with the provided in section 1538 with the Florida State Statute. Proposed cause of the panel shall be appointed for the consideration of the violation of the law to make findings shall be reported with the full commission if an improbable cause makes the determination of the probable cause of the commission shall issue the administrative complaint and shall be issued the cease and desist order provided in section 1538 Florida State Statute. If necessary, to stop the violation, probable cause panel shall be appointed with the serve as follows. The chair of commission shall appoint with 3 people the probable cause panel, but shall designate chair. At least one of the panel shall be a current member of the commission. Other members may be current commission members of the previously members of the commission of the Independent Education, State Board of Independent College and University, State Board of the Non-Public Career Education. And each probable cause of the panel shall serve on an ad hoc basis of review of the specific causes cases referred to and to by the commission. Current commission members who serve on the probable cause panel cannot vote with the final agency action of the institution who a current case that has been reviewed by the serving of the panel. D. See the reconsideration probable cause of the giving end of the case that is put forward by the members of the panel initially found with the probable cause in the case. Wherever the original panel member is not available, the current members shall hear the reconsideration. D. All investigation records, including the finding of the exemplary probable case causes panel that are exempt with the section 119.0.071 Florida State Statute, section 24A, Article 1 of the State Constitution for a period not exceeding 10 days for the panel make for the determination regarding probable cause. Alright, E. The Commission will review the recommendation probable cause panel with the probable cause found the Commission for the issue of the administrative complaint. The Commission also has the authority to issue the administrative fine with $100 to $5,000 per account. The Commission has also the authority to issue the cease and desist order provided in section 1538 when necessary to stop the violation. After the Commission shall determine the amount of the cost to be assessed and with the consideration affidavit itemized copy with any written objections submitted with the Commission of Independent Education. In any case, the Commission imposed the actual administrative fines, the assessment of the cost then shall be paid within 30 days for the date and final order of the Commission filed with the clerk of the Commission, less than different time frame with the set forth in final order. 8. Issues of citations. All citation will be included the requirement of the subject of a current violation of the remedial with a specified period of time not exceeding 60 days. Post whatever the other obligation will remedy the offense. The Commission shall be entitled to recover the cost of investigation, prosecution, in addition with the fine levied with the pursuant to the citation. The citation must be final order of the Commission if the subject fails to dispute the issuance of the citation within 30 days of the service. The subject within 30 days from the day of the citation becomes final order to pay with the final cost. The failure to pay with the final cost may be prescribed time period constituting a violation of section 1005-385 Florida State Statute, which will result in further disciplinary action. All fines and costs are paid to be payable to the Office of Comptroller, Department of Education. Once the citation becomes final order, the citation complaint will become the public record pursuant to Chapter 119 Florida State Statute unless otherwise exempt with the provision in Chapter 119 Florida Statute. The Executive Director will report the Commission the number of the citation issued and the nature of the offense for which they were issued with violation. Penalty for the citation. Citation shall be issued with the Executive Director for a failure to meet the procedural requirement of the Commission. For the purpose of the rule, the Commission designates as an offense the citation only with the following violation with the accompanying penalty. Issuance of worthless bank check to the Commission, 100. Failure to notify the Commission of the change of address for the time of the violation, paragraph 6E20061 4J, Florida Administration, 500. Failure to notify the Commission of the minor modification of the program rule, 62E2008, Florida Administration Code, 250. Failure to meet the Commission deadlines within 30 days of the second request, 100. Failure to report the Commission for the second request within 30 days of the second request, 100. Failure to submit the substantive change notification commission by subsection 6E100357 Florida Administration Codes, 500. Failure to provide access to employee commission to designate with inspection institutions on an on-site visit, 500. Our cease and desist order. Cease and desist order shall be issued with the Commission upon findable probable cause in conjunction with the notice for the denial of licensure shall comply with the section 1538 other applicable laws. 10. Injunction. The Commission shall seek injunctive relief of other applicable civil penalties provided in Section 1538 with other applicable laws and any after conducting an investigation performing the violation. Chapter 1005 Florida State Statute has occurred, but the Commission deems is serious and enough to other available remedies if there's not sufficient to stop the potential damage to the public. 11. Due to the procedure for the Commission shall notify the institution agent, certified mail, and any disciplinary action, give them with the grounds for the action explanation for the institution for the agent right. Agent's right to hear the hearing. Through a hearing, the institution agent shall have the 20 days to respond with certified mail indicating any question for a formal, informal hearing concurring with the Commission action. A. The failure on part of the institution agent to respond with the certified mail within 20 days, but does not shall constitute default. In the next regular special meeting, the Commission shall have received the evidence for the case and enter the final order. B. The institution agent may request the information hearing with the Commission no material fact or dispute if the institution of the agent or the Commission agrees to hold the informal lieu of the formal hearing. Procedure for the informal hearing shall be in accordance with the Section 120.572 Florida State Statute. After hearing the presentation of representative of the Commission, institution agent of the Commission shall enter the final order. The institution agent shall may request the formal hearing with the administrative judge of the Division of Administrative Hearings and material fact with the dispute. Procedure for the formal hearing shall in accordance with the Section 120.571 Florida State Statute. After receiving the recommendation order of the hearing, the officer of the Commission shall enter the final order. D. An affected party who has been reserved the seat for the desist order of the Commission may request the formal informal review of the order with the subsequent above may request the Commission Division Administrative Hearings to modify and abate the cease and the desist order. Affected party with the aggravated with the decision procedure without the review. The party may seek the interlocutory judicial review of the appropriate district court appeal provided in Section 1005 38.7 Florida State Statute. Rulemaking 1005-22 1E1, 1005-32-7, 1005-38 Florida State Laws, 1005-32-7, 1005-34-3, 1005-38, 1005-38-5 Florida State History News. October 13, 1983, formally 682-061, amended May 20th, 1987, November 27th, 1988, November 29th, 1989, December 10th, 1990, October 19th, 1993, January 7th, 2003, July 20th, 2004, May 18th, 2005, June 13th, 2005, February 20th, 2006, and July 10th, 2006. Alright, 6E2008, approval of modifications.